Good evening and welcome to True Grit Crime. I am your host, Mama Libra Scales. I'm sorry I'm a little bit late. I got really honestly sidetracked watching other channels. Um, because there's a lot going on with all of these different documents that have been dropped today. So it's a lot to
There's a
read.
lot going on with all of these
Hold
different
on.
documents that have been dropped today.
It's a lot to read. It's a lot to go over. So yeah, it's crazy. So what I wanted to do tonight was I wanted to go over the um, motion to disqualify that was filed by the defense. Originally, this document was slated to be a 24-page document, and it looks like that it's been amended um, to 30 pages. So tonight I'm going to go over the motion to disqualify. And then tomorrow morning, I'm going to do another live and go over the rest of the documents that were released today. So without further ado, I will go ahead and start sharing my screen. And okay, so let's see. Obviously, state of Indiana, county of Carroll, versus Richard Allen, cause number 08C012210 MR000001. Defense second verified motion to disqualify judge and request for finding of fact and conclusions of law upon denial of this request if the court denies this request. So comes now the accused, Richard Allen, by attorney Rossi and Baldwin, and pursuant to Rule 2.4 of the Indiana Rules of Criminal Procedure and the Indiana Code of Judicial Conduct, move for a change of judge from Judge Frances Siegel on her recusal from this cause. In support of said motion, Richard M. Allen swears and affirms as follows. The filing of a motion for disqualification and or request for recusal strips the court of jurisdiction to decide on any matters until the ruling on the disqualification motion occurs. Lucas versus State, 249 Indiana, 637 Indiana, 1968, citing Weir versus State, 37 NE 2D 537. Number 2, pursuant to Indiana Criminal Code of Procedure 2.4b, the state or defendant may request a change of venue from the judge only for bias or prejudice. The motion must be accompanied by an affidavit signed by the defendant or prosecuting attorney. The affidavit must set forth facts and reason for the belief that bias or prejudice exists. If the defendant signs the affidavit, the defendant's attorney must file a certification that the attorney believes in good faith the facts recited in the affidavit are true. The court must grant the request if the fact recited in the affidavit support a rational inference of bias or prejudice. Put another way, the facts contained in the affidavit must show that there is a reasonable bias to question the judge's impartiality toward Richard Allen and his defense team. Number 3, concomitant with Indiana Criminal Rule 2.4b is Rule 2.11 of the Indiana Code of Judicial Conduct, which requires the judge to disqualify himself or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action. The rule on disqualification and the canon on recusal both adopt a threshold of reasonableness, i.e., would an objective person have a reasonable basis doubting on the judge's impartiality. Number 4, the comments to Rule 2.11 of the Indiana Code of Judicial Conduct provide additional guidance. Number 1, under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. In many jurisdictions, the term recusal is used interchangeably with the term disqualification. Number 2, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Number 5, a judge should disclose on record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. Number 5, the test under the canon is whether an objective person, knowledgeable of all circumstances, would have a reasonable basis for doubting the judge's impartiality. The question is not whether the judge's impartiality is impaired in fact, but whether there exists a reasonable basis for questioning a judge's impartiality. Tyson versus State, 622 NE 2D 457 459, Indiana 1993. Opinion of Chief Justice Shepard recusing himself from consideration of a petition for transfer. This legal standard is not lofty. Number 6, the accused has a federal due process right to an unbiased judge under the 5th and 14th Amendment to the U.S. Constitution. Judicial bias is one of the narrow classes of constitutional violations that implicate structural error. Cases of judicial bias involve a denial of the most fundamental constitutes of due process, so fundamental that a conviction in their absence is indecent, even if the defendant is plainly guilty. Tyson versus Trigg, 50 F 3D 436 422, 7th Circuit, 1995. Structural errors render a criminal trial fundamentally unfair and are not subject to harmless error analysis. Arizona versus Fulminate, 499 U.S. 279, 111 as count 2, 1246, 1991. Number 7, the preamble to the Code of Judicial Conduct provides that judges should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. Richard Allen incorporates his first verified motion to disqualify filed January 28, 2024, as if fully set out herein. Number 8, after the Supreme Court quickly reinstated the defense following oral arguments on the same day, the Indiana Supreme Court did not grant Allen's request for Judge Gold to be recused based upon the limited record set out at the time by Allen's appellate counsel. Number 9, on January 28, 2024, the defense filed its motion requesting Judge Gold to be disqualified, knowing that the Indiana Supreme Court was not aware of all of the reasons Allen could cite that showed a rational inference of bias. Number 10, the defense cited 18 reasons for Judge Gold to recuse herself in that January 28, 2024 motion. Number 11, on February 6, 2024, before finding out exactly why the Indiana Supreme Court rejected Allen's request to have her removed, Judge Gold denied the defense request for her to be removed. Number 12, Judge Gold's one sentence denial of the defense motion to have her disqualified stated, the courts having defendant's verified motion to disqualify filed January 28th, 2024. Defendant's affidavit filed January 28th, 2024, and certification of Richard Allen's attorneys filed January 28th, 2024, under advisement and having considered the pleadings, now denies the verified motion to disqualify without hearing, as the Indiana Supreme Court unanimously denied defendant's previous request on January 18th, 2024. Emphasis added. Number 13, had Judge Gull waited only 2 more days before ruling on the defense motion to have her disqualified, she would have had the benefit of learning exactly why the Indiana Supreme Court did not disqualify Judge Gull. On number 14, on page 16 of the order reinstating Baldwin and Rossi, the Indiana Supreme Court stated that Allen, through his attorneys, did not identify anything Gull, has done that demonstrates she isn't impartial. Indiana Supreme Court opinion, page 16. The Indiana Supreme Court's opinion detailing the reasoning for not taking Judge Gull off the case was issued on February 8th, 2024, and certified on February 15th, 2024. Number 15. At the time the Indiana Supreme Court issued its opinion, the court did not have the benefit of reviewing the 18 reasons the defense cited in its January 28th, 2024 filing, which the defense claimed supported a showing of Judge Gull's bias. Certainly, some of those 18 reasons were included in the Indiana Supreme Court's opinion as by themselves not being enough to cause Judge Gull's recusal. However, many of the examples of bias identified by the defense in its January 28, 2024 motion were not cited by Allen's lawyer in their request for Judge Gull to recuse herself. Number 16. In other words, Judge Gull's use of the January 18, 2024 Supreme Court ruling as a sort of blanket immunity to support her decision to not disqualify herself was wrong, in that the Indiana Supreme Court's February 8, 2024 opinion leaving Judge Gull on the case was clearly based on a very finite set of reasons argued by Allen's appellate attorneys, and not the longer list of reasons articulated by Baldwin and Rossi in their motion to have Judge Gull disqualified. Judge Gull ignored that longer list and instead erroneously used the Indiana Supreme Court's ruling as her reason to remain on the case without any legal analysis and before reading the Indiana Supreme Court's opinion. Number 17, the defense is requesting that if Judge Gull does anything but recuse herself from this case, that she issue findings of facts and conclusions of the law that support her decision to deny the defense's motion rather than one sentence order summarily denying Richard Allen's request. Number 18, in addition to the reasons cited in the January 28, 2024 motion, Judge Gull has revealed a rational inference of bias toward the defense based on the following. A, Judge Gull engaged in ex parte communication with the state of Indiana. B, Judge Gull inferred with a properly subpoenaed defense witness. C, Judge Gull treats the prosecution more favorably than the defense. D, Judge Gull engaged in the act of prosecuting Richard Allen by inviting the prosecutor to file pre-trial motions seeking the limitation of evidence of third-party culpability and also forecasting the outcomes of such a request by the state. E, Judge Gull continues to make disparaging comments about defense counsel in open court and orders issued by the court. Better cite local. I mean, it's like she's a whole meme of her own. Yeah, it's It's crazy. It was actually like really interesting to watch this entire thing. And as I've stated before, in my opinion, and from what I have seen, um, there seems to be nothing that the defense has tried to do to stop this. Like she's just been very snarky every time. So, um, Judge Cole continues to make disparaging comments about defense counsel in open court and in orders issued by the court. Yes, she does. F. Judge Cole's handling of defense pleadings versus her handling of prosecution's pleadings. G. Judge Cole placed blame on defense counsel and its staff for administrative failures in maintaining confidentiality of ex parte defense filings, whereas evidence revealed that failures were on the court's side of the filings. H. Judge Cole failed to conduct her own internal investigation into allegations of leaks coming from her own staff while facilitating contempt proceedings against Richard Allen's chosen attorney for leaking confidential information related to this case. Denied. Someone write a letter to her with a meme of herself. I'm not so sure that would be the exact way that you want to handle it, although it would probably make her pretty mad. I mean, she's pretty angry about her personal emails being in filings. Could you imagine her personal memes showing up, like the memes that have been made about her showing up in personal filings? I think that woman would hit the roof, to be honest. So, Judge Cole effectively denied Richard Allen's right to a speedy trial by not requiring the prosecution to follow the same restrictions at trial as she was forcing the defense to follow, which forced the defense to seek a continuance of the May 13th, 2024 speedy trial date. Ex parte communications and interfering with defense witnesses. Number 19, Judge Cole participated in ex parte communications with the state of Indiana through its witness to the detriment of the defense. 20, on April 5th, 2023, Richard Allen, by counsel, filed his emergency motion to modify a safekeeping order based on the conditions of his confinement at Westville Correctional Unit. 21, on April 14th, 2023, Judge Cole entered an order stating the Indiana Department of Corrections was authorized to move the defendant within the Department of Corrections to accommodate his medical and physical needs pursuant to medical directives by DOC physicians, psychiatrists, and psychologists. Number 22, on May 4th, 2023, Mr. Allen, by counsel, filed his motion to reconsider and request for due process hearing, which the court set for hearing on June 15th, 2023. Number 23, in preparation for the hearing, the defense served a valid subpoena on witness and Westville inmate Robert Baston to appear for the June 15th, 2023 hearing. Number 24, when a deputy from Carroll County Sheriff's Department went to Westville Correctional Unit on June 14th, 2023 to transport the inmate to the hearing, the inmate became uncooperative. Carroll County Chief Deputy Tobe Lesenby contacted Judge Cole about the situation, and Judge Cole told Deputy Lesenby to leave the inmate there if he did not want to come to the hearing. Number 25, Tobe Lesenby was the first witness called by the prosecution at the June 15th, 2023 hearing, and certainly will be called as witness at trial, yet Judge Cole or her staff communicated with this prosecution witness the day before his testimony without the full disclosure of said communication to the defense. Damn. That's messed up. You know you're not supposed to be doing that, Missy. Number 26. Additionally, Tony Liggett, who was a witness at the June 15th, 2023, and will be a witness when this matter goes to trial, issued a report in which he stated, on the 14th day of June 2023, communication with the court was established by Sheriff Major Chief Deputy Tobe H. Lesenby, wherein Major Lesenby was advised by the court to disregard any further efforts to retrieve inmate Baston from the Westville Correctional Facility. Emphasis added. 27. On June 14th, 2023, Judge Gold sent an email to the parties stating, FYI, the Carroll County Sheriff Transport Officer went to Westville to pick up the inmate requested by the defense team per subpoena. The inmate refused to come out of his cell and demonstrated an ability to fight if forced. The transport officer stood down and left the facility to return to Carroll County without said inmate. I have asked for a formal written report on those activities, which will provide to you upon request. Upon receipt. My bad. 28. What Judge Cole failed to tell the defense in that email is that she was the person who used her authority as judge to direct the Carroll County Sheriff's Department to ignore a valid subpoena of a defense witness scheduled to testify at an important hearing on behalf of the defense. Number 29. It is not unusual for those incarcerated to not cooperate when being transferred from one facility to another when presented with a subpoena. However, the lack of cooperation of an inmate is not a legal justification for a judge to direct the IDOC or the county sheriff transport officer to simply ignore a valid subpoena. So on page 10 at the bottom, the footnote here, I want to read that. Judge Cole has detailed on one or more occasion her vast experience on the bench. It would be surprising if this situation has not occurred in her tenure on the bench. And give me just a second. Okay, sorry guys, I'm back. Okay, so going back here to page 11, number 30. The proper method for a judge facing that situation would be to not communicate in an ex parte fashion with witnesses who are involved in the case. Rather, it would be to contact the attorneys for both parties, prosecution and defense, explaining that the court has been informed that there is a potential problem with transportation of the witness from IDOC and that the court will not talk to the state of Indiana without talking to both sides. Then after both sides are engaged to work on a solution. If the defense still wanted the witness to attend the hearing, then law enforcement would be required to use whatever means necessary to transport the inmate unless the state of Indiana filed a motion to quash the subpoena, which was granted by the court. Number 31. After the June 15, 2023 hearing, Judge Gold denied Mr. Allen's motion to reconsider, stating the evidence presented demonstrated at the hearing on defendant's motion to reconsider did not support many of the allegations advanced by defendant's counsel. In fact, the evidence presented demonstrated that the defendant is treated more favorably than other inmates housed at the Westville Correctional Facility. This is disingenuous, given that Judge Cole prevented the defense from presenting the very evidence she said was lacking. Number 32. Any perception of Judge Cole's bias was supplanted with proof of actual bias when Judge Cole denied Mr. Allen's motion to reconsider, claiming a lack of evidence when she prevented Mr. Allen from presenting the testimony of Mr. Baston. Communicating with the state's witness in an ex parte fashion provides a rational inference of bias. Issuing a directive for the state's witness, Carroll County Sheriff, to ignore a valid subpoena to the detriment of the defense provides a rational inference of bias. Judge Gould's failure to fully inform the defense of her involvement in directing law enforcement to ignore a properly issued defense subpoena demonstrates deception. Such deception to the defense provides a rational inference of bias against the defense. Recent ex parte communication and additional evidence of Judge Gould's favorable treatment to the state of Indiana as opposed to her treatment of Richard Allen and his defense team. On May 3rd, 2024, the defense deposed Sheriff Tony Liggett. During this deposition, it was learned that the court has engaged in activities with law enforcement and prison representatives regarding Richard Allen's housing, both during scheduled jury selection in Fort Wayne and during the scheduled jury trial in Carroll County, Indiana. The court failed to communicate any of these plans to the defense in advance of the court's actions. Again, the court appears to have engaged in ex parte communication with the state of Indiana. At the June 15, 2023 hearing concerning the pretrial housing of Richard Allen, Sheriff Liggett claimed that the only reason he objected moving Richard Allen to the Cass County Jail, approximately 25 minutes from Delphi, was due to the lack of manpower to transport Richard Allen to and from the jail. During the May 3rd deposition, Sheriff Liggett acknowledged that Richard Allen was set to be housed at the Tippecanoe County Jail during the scheduled jury trial, and that the transportation of Richard Allen to and from the courthouse was arranged. Therefore, there is no need to continue to house Richard Allen at a prison some 2.5 hours from Carroll County during the pendency of this case. According to Sheriff Liggett, Judge Gould is aware of these circumstances. Despite this, Judge Gould failed to communicate or even inquire with the defense about Richard Allen's housing circumstances. It is also true that despite alternative detention options, Judge Gould has failed to intervene and protect Richard Allen, who at this moment in time is presumed innocent from his appalling confinement conditions, by facilitating a more suitable pretrial housing arrangement for Richard Allen while he awaits trial. Judge Gould's actions of ignoring the defense in matters related to the housing of their client while continuing to communicate with the state of Indiana in an ex parte manner provides a rational inference of bias against Richard Allen and his defense team. Judge Gould invited the prosecution to seek limitations on Richard Allen's Sixth Amendment right to prove that other parties committed this crime in question. My goodness. Both Judge Gould and the prosecution have known since the filing of the first Frank's notice on September 18, 2023, that the defense will be relying on a third-party suspect defense. In rebuttal to the defense's theory regarding third-party perpetrators, the prosecution listed an Odinism expert on their supplemental witness list emailed by the defense on March 17, 2024. At no time between September 18, 2023 and April 27, 2024, did the prosecution take any action to prevent the defense team from pursuing a third-party perpetrator defense. During this time, the defense conducted many depositions related to their third-party perpetrator defense, and in addition, made numerous requests to the state seeking additional discovery regarding third-party suspects. On April 28, 2024, Judge Gould directed an email to both the prosecution and the defense regarding scheduling matters, and without any prompting, informed the defense that she, Judge Gould, was fully aware of the law regarding the third-party perpetrator defense and would be prohibiting the admission of such evidence by the defense unless some nexus between the two could be proven. This unprompted comment was akin to an invitation by Judge Gold to the prosecution to file a motion in limine that would prevent the defense from presenting evidence that third-party suspects committed the murders. Approximately 12 hours later, at midnight on Sunday night, or on a Sunday night, the prosecution filed its motion in limine requesting that Judge Gold not allow the defense to discuss third-party suspects. The court's invitation to the prosecution to seek such limitations creates a rational inference of bias in favor of the state of Indiana and against the defense. Judge Gold has repeatedly disparaged Richard Allen's appointed public defender. Beginning October 19th, 2023, Judge Gold begins verbalizing her negative feelings about Richard Allen's defense team using such words as grossly negligent and incompetent. When Richard Allen's original defense team attempted to enter their appearance for Richard Allen pro bono, Judge Gold would not allow their appearance to be entered based upon her view that the defense attorneys were grossly negligent and that Richard Allen could not even expect an adequate defense from the attorneys Baldwin and Rossi. In her comments at the October 31st, 2023 hearing, Judge Gold stated the following: I cannot and will not allow these attorneys to represent you with the concerns that I've had with the gross negligence, but I have found, emphasis added, these words alone equate to outright bias on the part of Judge Gold toward the defense and toward Richard Allen. Since denying the defense motion to disqualify, Judge Gold has continued to show her bias in every variety of ways, including demeaning Richard Allen's defense lawyers who have between them over 50 years of experience and zero findings that they are incompetent or have violated the professional rules of conduct. Most recently, in her April 30th, 2024, two-page order detailing her ruling on the prosecution's request to find the defense attorneys in contempt, Judge Gold continued her maligning of the defense attorneys, calling them incompetent, negligent, and sloppy in a way that they handled evidence. Judge Gold stated the following to Richard Allen at the October 31st, 2023 hearing. Mr. Allen, I understand that you wish to have Mr. Baldwin and Mr. Rossi represent you in this matter. I have grave concerns, Mr. Allen, about their representation of you, the previous findings by this court of their gross negligence. Mr. Allen, you are entitled to adequate representation in your case. You are entitled to a vigorous defense in your case. And this is difficult, Mr. Allen, but I know you want. You've indicated that through your attorneys, but I cannot and will not allow these attorneys to represent you with the concerns that I've had with the gross negligence that I have found. Emphasis added. Furthermore, in that same order, Judge Gold articulated to not only the lawyers but the general public that she would be referring her findings to the Office of Judicial and Attorney Regulation. Judge Gold's targeted comments and reference to the Office of Judicial and Attorney Regulations have no legal relevance to her findings of non-contempt and appear to have been intended only to further disparage the character and fitness of defense attorney Rossi and Baldwin. While Judge Gold has on at least 8 occasions denied defense motions with 3 words, denied without hearing, Judge Gold felt it necessary to use insulting language concerning defense counsel only 2 weeks before the beginning of trial. The fact that Judge Gold continues to disparage the character and fitness of defense counsel when she could have otherwise remained silent on the matter provides a rational inference of bias against the defense. Other examples of Judge Gold treating the prosecution more favorably than the defense: at the March 18, 2024 contempt hearing, the defense provided evidence to the court that the Carroll County prosecutor, Nick McClellan, interacted with a social media content provider named Gary Bedet, aka Fig. The evidence was in form of emails, including an email in which Fig claimed that McClellan had requested Fig to erase their communications. The defense provided evidence that other leaks occurred over the case's history, implying that those leaks could have emanated from McLeland's office. While Judge Gold required the defense to cooperate in the investigation of leaks attributed to the defense, Judge Gold seemingly had no interest in similar allegations attributable to the prosecution. Judge Gold's actions, as referenced in the various photographs or paragraphs above, created a rational inference of bias against the defense and in favor of the prosecution. Judge Gold treated the defense team differently than she treated her own office regarding allegations of confidential discovery matters. At March 18, 2024 contempt hearing, the defense tendered evidence to Judge Gold that showed that her staff may have leaked confidential information to social media sources. This evidence included emails and video from a content provider named Big and others, as well as testimony from other witnesses. In November 22nd, 2022, social media video tendered to the court, Big detailed sensitive crime scene information that at the time was not available to the public. At the time Big detailed his knowledge of crime scene information, that information was in possession of the court. The defense then attempted to provide emails and did provide testimony to the court in which a witness, Steve Wood, testified that Big told him, Steve Wood, that his source of that confidential and sealed information was someone on Judge Gold's staff. Judge Gold has shown no concern whatsoever about unmistakable evidence on that November 22nd, 2022. Gary Fig Badet revealed sensitive crime scene information at a time when the information was not known by the public, later claiming that he, Fig, received said sealed information from Judge Gold's staff. Judge Gold has called the defense incompetent, negligent, grossly negligent, and sloppy concerning the very same allegations against her staff that Judge Gold has apparently refused to investigate. My, oh my, oh my. The plot just keeps on thickening, right? I mean, we already knew this. It's not really any new news when it comes to this whole entire situation. My goodness. The defense has no idea whether Judge Gold's court staff leaked sensitive information to his social media site, but there does exist facts to support this allegation. Despite these facts, the defense is aware of no action taken by Judge Gold to investigate these circumstances. So on page 19, the footnote, the defense attempted to admit Exhibit Q, which was a flash drive containing a YouTube video from November 22nd, 2022, in which Fig announced his knowledge of the bullet purportedly found at the scene when this information was still sealed. The judge refused to admit said document as part of her analysis for contempt, but it was accepted as part of the record for appellate purposes, page 139 to 140 of the record of proceedings at court hearing on motion for contempt held March 18, 2024. This flash drive is still available for Judge Gold if she becomes concerned that either McLeland or someone from her office was leaking information to Gary Fig Badet. Record of proceedings at hearing on motion for contempt held March 18, 2024, page 141, lines 1 through 25, page 142, lines 1 through 14. This is a stark contrast from the actions of Judge Gold, who in the fall of 2023 endorsed the prosecution and its law enforcement personnel in seeking out suspects associated with the leak of crime scene photos to the public. The fact that Judge Gold has treated the defense differently when the defense is accused of a leak than it has treated her own staff or the prosecution creates a rational inference of bias against the defense. Judge Gold wrongly blamed the defense for ex parte filings, which were inadvertently directed to the prosecutor. The defense learned from a prosecution filing that the prosecution had somehow received Mr. Allen's ex parte documents that were not to be viewed by the prosecutor. Upon inspecting how this happened, the defense determined that Judge Gold's staff or the county clerk errantly misdirected these documents to the prosecutor. When the defense counsel staff reached out to Judge Gold's staff to determine why and how multiple ex parte motions had been sent to the prosecutor, Judge Gold, without investigating this matter, fired off an email to the defense disparaging its staff and placing the blame on the defense. Having been accused by Judge Gold of making the mistake, the defense staff member who filed the ex parte motion then reached out to DocsPop to make sure that she was filing the ex parte motion correctly. It was determined that the defense was filing the motion correctly. The entity responsible for sending the ex parte documents to the prosecution, therefore, was either Judge Gold's staff or the Carroll County clerk. It's not very surprising, is it? Attorney Rossi then reached out to the Carroll County clerk, who maintained that she had correctly handled the ex parte documents. The defense is in possession of screenshots which prove that defense counsel's staff filed the ex parte matter confidentially, and that proves that the defense staff provided service only to attorneys Rossi and Baldwin and not McClellan or any other persons. This is proof that the defense staff followed the rules for filing ex parte motions. The defense did not send out the ex parte motion to McClellan in spite of Gold's quick accusations. Judge Gold failed to investigate how such a significant error could have been made to avoid misdirected ex parte filings in the future, but rather simply blamed it on the defense. Judge Gold's reaction in blaming the defense for the ex parte leak of information, when the leak appears likely to have emanated from Judge Gold's own staff, shows a rational inference of bias. Accusations of violating rules on access to court records. Due to the way Judge Gold maintained the records on this case, attorneys Margaret Smith and Kara Weineke entered their appearance and filed a petition of writ of mandamus and prohibition. I think I'm saying that right. Original action. Following Smith's and Weineke's original action for writ of mandamus, Judge Gold hired a lawyer and then was forced to cure most of the issues that Smith and Weineke identified prior to the hearing in the Indiana Supreme Court. In other words, Judge Gold and her attorney recognized that she inherently violated the rules on access to records and then cured those errors, calling the defense incompetent, grossly negligent, and sloppy, while ignoring the fact that both the court and the prosecution have been accused by others of behavior that might or would be considered incompetent, grossly negligent, or sloppy. Provides a rational inference of bias. Defense motions are treated differently than those of the prosecution. While at least 5 outstanding defense motions were pending related to the merits of the case, all which needed to be ruled on as soon as possible for purposes of trial preparation for the defense, Judge Gold chose to not issue orders or set hearings on any of those motions. Instead, Judge Gold chose to spend valuable court time setting a half-a-day hearing on the prosecution's motion for contempt. The prosecutor's motions for contempt did not address the merits of the murder allegations against Richard Allen, nor was the contempt motion a time-sensitive matter. There is no reason that the contempt hearing could have not taken place after Mr. Allen's trial. The prosecutor filed his motion for contempt against the defense on January 29, 2024. 3 days later, February 1st, 2024, Judge Gold issued an order setting the matter for hearing. The defense had never received such a quick setting on any of its motions. Even at this moment, several outstanding motions have yet to be ruled on. For example, the record shows that on more recent pleadings filed by the parties, Judge Gold quickly prioritized the prosecution's request for contempt over the following defense motions. Motion to suppress confessions. The defense filed this motion on April 11, 2024, but it was ignored by the court until the recent May 7, 2024 hearing. Again, It took Judge Gold only 3 days to file a written order addressing the prosecution's motion for contempt by setting it for a hearing only 2 weeks later, while Judge Gold failed to even acknowledge the defense motion for suppression of a confession for nearly a full month, and then only did so at that hearing. Motion to suppress the accused's second statement. The defense filed this motion on April 15, 2024, but it was ignored by the court until the recent May 7th, 2024 hearing. Again, it took Judge Gold only 3 days to file a written order addressing the prosecution's motion for contempt by setting it for hearing only 2 weeks later, while Judge Gold failed to even acknowledge the defense's motion for suppression of the accused's Second Amendment for over 3 weeks, and then only did so at the hearing. Motion to compel and for sanctions. The defense filed this motion on April 23rd, 2024, but it was ignored by the court until the recent May 7th, 2024 hearing. Again, it took Judge Gold only 3 days to file a written order addressing the prosecution's motion for contempt, while Judge Gold failed to even acknowledge the defense's motion to compel and request for sanctions for over 2 weeks, and then only did so at the hearing. Motions for Franks 3. The defense filed this motion on March 13th, 2024. Judge Gold has ignored the defense filings now for 62 days through May 14th, 2024. Again, it took Judge Gold only 3 days to file a written order addressing the prosecution's motion for contempt by setting it for a hearing only 2 weeks later, while Judge Gold failed to even acknowledge the defense's third Franks motion even up until the time of this filing. Rulings on the first Frank motion. Additionally, while it took Judge Gold over 4 months to rule on the first Franks motion denied without hearing, it only took Judge Gold 43 days to issue an order on the prosecution's request to find the defense attorneys in contempt following a half a day of testimony. The prosecution's contempt motion is not relevant to the merits of the case, while the defense various motions described above are relevant to the merits of the case. Yet Judge Gold acted on the prosecution's motion within 3 days while ignoring the defense motions for weeks. Judge Gold ignored other older defense pleadings sometimes for months before ruling. Many defense motions have resulted in Judge Gold issuing an order stating 3 words, denied without hearing. Since their reinstatement alone, Judge Gold has denied defense motion without hearing a total of 8 times, including denying motions to compel discovery, which Mr. Allen needs to prepare for his defense. Judge Gold's quick treatment of the prosecution's motion on matters ancillary to the innocence or guilt of Richard Allen versus Judge Gold's treatment of defense motions that are related to the merits of the case provide a rational inference of bias for Judge Gold's bias for the prosecution and against the defense. Certainly, it appears that Judge Gold used the prosecution's motion for contempt as a vehicle to malign the defense while simultaneously ignoring matters raised by the defense that would malign the prosecution for its handling of discovery. This provides a rational inference of bias against the defense. Judge Gold ignored the defense's request to set aside 2 weeks to present Mr. Allen's defense while refusing to set any time limits on the prosecution. On or about October 4th, 2023, Mr. Allen's counsel notified the court that they would need approximately 2 weeks to present his defense. In an aforementioned April 28th, 2024 Sunday morning email, Judge Gold sua sponte issued a stern message in that email indicating that the trial would end on May 31st, 2024, not more or less. Before issuing her order on the days allotted for trial, Judge Gold failed to reach out to the parties in order to determine how many witnesses were expected to testify, the expected length of the testimony, how many videos were expected to be played, the lengths of those videos, and most importantly, how long each side expected their case to last based upon the evidence that they expected to present. Between all defense counsel with a combined 70 years of experience, not one time have they been told that a trial would absolutely end on a certain day and not go any longer. Judge Gold's inflexibility only impacts the defense as the prosecution presents its case in chief first, and therefore likely would have enough time to put on its case, leaving the defense with little or no time to put on its case in chief. Richard Allen possesses constitutional rights for the compulsory process of having witnesses testify on his behalf and to confront witnesses pursuant to the Sixth Amendment of the Constitution of the United States, as well as the right to present a complete defense pursuant to the 14th Amendment. When the defense asked Judge Gold at the May 7th, 2024 hearing if the state of Indiana would be forced to abide by the same time constraints as the defense, Judge Gold would not commit to such a requirement of the prosecution. Out of fear for the prosecution would run out the clock and leave the defense with minimal time to present its case, Judge Gold forced the defense to accept her remedy of continuance of a speedy trial. Because of Judge Gold's refusal to guarantee the defense the same amount of time for trial as the prosecution, Richard Allen was, for all intent and purposes, denied his right to a speedy trial. All the above circumstances create a rational inference of bias against the defense and in favor of the prosecution. Judge Gold engaged in extrajudicial activities that raise a rational inference of bias, especially when Judge Gold may have to rule on how the extrajudicial activity of a key state's witness will impact admissibility of Richard Allen's purported confessions. Judge Gold was appointed to preside over this case on November 4th, 2022. Since being appointed as special judge, this case has become one of the highest profile cases in recent memory, even receiving worldwide attention. The victims of the murders are Abby Williams and Libby German. On July 9th, 2023, more than 8 months after being appointed to the case, Judge Gold chose to comment on a post concerning a softball tournament at the Abby and Libby Memorial Park. The post upon which Judge Gold was commenting stated, "What an honor it was for the girls to play in the Abby and Libby Memorial Tournament. What a greater honor it was that Abby and Libby's grandparents present our girls with their championship finalist rings." Judge Gold comments was, "Congratulations." While seemingly in a caucus, Judge Gold's choice to comment on a post involving a softball tournament, celebrating the lives of the victims of the crimes in which Judge Gold is presiding judge, was inappropriate. Certainly, when factoring in the other issues raised in the first motion to have Judge Gold disqualified, as well as the issues raised in the second motion to disqualify, Judge Gold's comments were even more inappropriate, providing an appearance of bias against Richard Allen and in favor of the state of Indiana, who is prosecuting the accused murderer of the victims who are identified in the post. The defense believes that Judge Gold's choice to comment on social media, as detailed herein, on its base supports a rational inference of bias as well as an appearance of bias. However, newly discovered evidence adds another layer of conflict and bias to Judge Gold's post. On May 6, 2024, the state of Indiana filed its formal request for a pretrial ruling on admissibility. Within said request, the state referenced Dr. Monica Walla as being a psychologist providing services to offenders at Westville Correctional Facility, one of those inmates being Richard Allen. Subsequent to the filing of said pleadings, members of the public began to discover evidence that Dr. Walla had joined and participated in social media forums, outlets, etc., involving the Delphi murders. Naturally, these facts were reported to the defense through various means. It is also true that the defense deposed Dr. Walla on Wednesday, May 8th, 2024, at the law office of Hillis, Rossi, and Dean. The deposition was not completed due to a timing constraint that will likely be reset in early June, at which time the defense expects the deposition to conclude. The defense was unaware of the apparent social media activities of Dr. Walla at the time of the deposition, and therefore the matter was not addressed. It wasn't until shortly after the deposition concluded that these issues were brought to the attention of Attorney Rossi, who conducted the deposition. Since May 8, 2024, the defense has become aware of information that suggests that Dr. Walla did in fact engage in social media activities related to the Delphi murders. The defense is not in a position to determine the extent and nature of said activities at this juncture without conducting further discovery. However, the defense is aware that the online personality purporting to be Monica Walla, including a picture of Dr. Walla, appears to have deleted and removed and or wiped clean any online presence related to the Delphi murders. This appears to have been done in the hours following the deposition referenced above. Again, this court is faced with a conundrum. The judge's decision to publicly comment on matters involving the death of two girls is evidence that Judge Cole does not find it inappropriate to engage in such communications about a pending case. How, then, can Judge Cole be impartial in making any determinations on the defense's motions to suppress or state's request for a pretrial ruling on admissibility of communication between Richard Allen and his state-appointed psychologist? If this court were to find that Dr. Walla alleged acts were inappropriate, then by extension, the same could be true about Judge Cole's actions. As a purported confession looms as potentially the most powerful evidence against Richard Allen, any appearance of bias or conflict that exists for Judge Cole as she makes determinations of the legal impact of the witness's social media activity on those purported confessions provide a rational inference of bias. Additionally, even when Judge Cole rules against the defense and does not suppress the purported confessions, Judge Cole will likely face a second legal argument: the admissibility of any social media postings of this witness that involve the Delphi murders in order to attack the witness's credibility. Should the prosecutor object, claiming that the witness's social media comments on Delphi case are inadmissible, Judge Cole will once again find herself in a conflicted position due to her own social media comment concerning a post involving the victims of the murders. Judge Cole's starting position apparently is that it was appropriate for her, Judge Cole, to choose to comment on a social media post concerning the victims' softball tournament. Therefore, it would be more likely that Judge Cole's starting position will also be that this Dr. Wallace social media post activities are similarly appropriate. With this starting position, the defense will face a heightened burden in arguing for the inadmissibility of Dr. Wallace's social media post activity. This additional hurdle, created at least in part by the court's inappropriate comment on social media, creates an inference of bias or prejudice against Richard Allen. Disqualification recusal is the appropriate action in terms of remedying this prejudice. Judge Cole has impaired Richard Allen's ability to defend himself by denying his reasonable request for expert and administrative staff funding. In 2023, the defense tendered bills for matters related to the defense of Richard Allen totaling over $38,000. Judge Cole has not authorized payment of those bills as of the date of this filing. Defense counsel has been forced to advance those expenses out of their own pocket. For example, the defense has paid $26,000 for work its investigator performed in the spring, summer, and fall of 2023. When Judge Cole was not satisfied with the format of the investigator's bill, the defense tendered a new bill to meet the court's expectation because the investigator deserved to be paid for the work he performed. The defense paid the investigator out of its own law firm account. After trying to rectify the issue Judge Cole had with the bill's format, Judge Cole has failed to order the payment of such expenses associated with the defense private investigator. The defense has sent multiple requests to Judge Gold and her staff seeking input as to why this bill has not been paid. Judge Gold has not responded to those requests. The lack of response to the request for payment creates a rational inference of bias. Also, why the prosecution has unlimited access to funds and local enforcement experts, Judge Gold initially denied the defense request for expert funds for certain experts needed for the defense of Richard Allen only after the defense filed requests for reconsideration and apparent public outcry. Did Judge Gold change her mind and provide the defense funds for those experts? The refusal to initially provide funds to the defense for experts provides a rational inference of bias. Evidence that public confidence in Judge Gold has eroded due to continued improper conduct and conduct that creates the appearance of impropriety. Evidence of the erosion of the public's confidence in Judge Gold can be shown through letters the judge has received, as well as letters the Indiana Supreme Court has received, as well as memes and other social media content that can easily be located on the internet. Find attached 14 letters and emails that members of the public have taken the time to draft and then sent either directly to Judge Gold or to the Indiana Supreme Court. These letters and emails provide evidence that the public perception of Judge Gold's ability to be fair and impartial has eroded. Multiple people paying attention to the case believe that inference of bias and prejudice against the defense exist to such a degree that they took the time to alert this court and the Indiana Supreme Court to what they are observing. The perspective of common everyday citizens, i.e., objectively reasonable people who have taken the time to voice their concerns about the apparent bias they are witnessing, should not be overlooked. On March 28th, Paige Moore wrote Judge Gold, among other things, Mr. Allen has denied funds for expert witnesses, even though Americans are guaranteed a fair trial. Experts are needed for forced confessions and bullet markings. On April 1st, 2024, Oscar Lopez wrote to Judge Gold saying, among other things, I have serious doubts that you, the judge presiding over this case, is capable of being fair and impartial judge in this case. March 29, 2024, Liza Trick wrote to Judge Gold, among other things, you are the most biased judge I have ever seen, and you ought to be ashamed of yourself. This is not a fair trial. March 27, 2024, LGW wrote, Judge Gold, among other things, it appears that the defense is being prohibited from being able to defend their client. On March 28, 2024, Stephanie Cope wrote Judge Gold, among many things, the following. I have watched every phase of this case gone through like many others. It's shocking and disturbing to see Mr. Allen and how his public defenders treated so unjust. I can't understand the lack of self-awareness you have concerning your own biased feelings. On March 29, 2024, Hope Douglas wrote Judge Gold the following. In my opinion, it is clear as an outsider looking at this case that you have presented your rulings as biased and almost always pro-prosecution. Judge Gold has refused to order the state to comply with discovery rules to the detriment of Richard Allen. The Indiana Code of Judicial Conduct 2.6 states that the judge shall accord to every person who has legal interest in a proceeding or that person's lawyer the right to be heard according to the law. Comment 1 states the right to be heard in an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedure protecting the right to be heard are observed. Emphasis added. Comment 2 discusses the important role that the judge plays in overseeing the settlement of disputes, indicating that the judge should be careful that efforts to further settlement of disputes do not undermine the party's right to be heard according to law, and that the judge keep in mind the effect that the judge's participation in settling disputes may have, not only on the judge's own view of the case, but also on the perceptions of the lawyers and the parties if the case remains with the judge after set efforts are unsuccessful. Emphasis added. ICJC 2.7 states that a judge shall hear and decide matters assigned to the judge except when disqualification is required by Rule 2.11 or other law. Comment 1 states that judge must be available to decide the matters that come before the court. The defense incorporates paragraphs 1 through 134 in support of Judge Gold's violation of ICJC 2.5, 2.6, and 2.7. Judge Gold has held only 2 hearings with current defense counsel since June 15, 2023, and 1/2 of the March 18, 2024 hearing pertained to the prosecution's hearing on contempt, unrelated to the merits of the case. Even though the defense has filed several motions seeking hearings on discovery matters that are deeply impacting the defense, Judge Gold has ignored the opportunity to assist in the resolution of those matters, either through a hearing or some other means. Judge Gold's refusal to act on discovery disputes raised by Richard Allen raises a rational inference of bias. Judge Gold has only allowed cameras in the courtroom once at the hearing when she knew one way or another that she was kicking attorneys Rossi and Baldwin off of the case. Rule 2.8b states that the judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals in an official capacity, and shall require similar conduct of lawyers, court staff, court officials, and others subject to the judge's discretion and control. The defense incorporates paragraph 1 through 138 in support of its contention that Judge Gold has violated ICJC 2.8. Judge Gold has run one of the test cords for camera in the courtroom and appears supportive of cameras in the courtroom. However, the only time in this case that Judge Gold has specifically allowed cameras in the courtroom was on October 19th, 2023. On that date, Judge Gold knew going into that hearing that she would either allow Attorney Baldwin and Rossi the opportunity to withdraw or proceed to the hearing in which she would read into the record a handwritten document she penned before the in-chambers hearing, disparaging and discrediting attorneys Baldwin and Rossi. Judge Gold's attempt to disparage the defense counsel with cameras in the courtroom, again, the only time cameras have been in the courtroom, violates ICJC 2.8 in addition to all the other facts pled herein. It would be difficult to believe that an objectively reasonable person would not believe that Judge Gold has demonstrated bias and prejudice against the defense. Her own words, grossly negligent, incompetent, and sloppy, are proof of these obvious facts. Beyond Judge Gold's words lie her actions. They are articulated throughout the body of this motion. Actions often do speak louder than words. The actions of Judge Gold warrant her recusal and or disqualification. The defense is requesting this court restore public confidence by withdrawing from this case. The defense is requesting this court to disqualify itself to reduce the likelihood of costly appellate litigation and the cost of the retrial should a negative outcome against Richard Allen result from the trial should she remain on the case. The cumulative effect of each piece of bias and prejudice recited herein supports the defense requests for a change of judge. Richard Allen, a man presumed innocent, deserves a fair trial, as do the victims' families and the entire Delphi community. Judge Gold's continued involvement in this case will leave a cloud of doubt over the legitimacy of the proceedings. Accompanying this motion is the affidavit of Richard Allen in which the defense requests to be incorporated into this document. The same affidavits sets forth the facts establishing the timeliness of defendant Allen's request for change of judge pursuant to RCP 2.4C2. And finally, this motion is also accompanied by a certification that Richard Allen's attorneys believe in good faith the facts recited in the affidavit are true and correct. Wherefore, the defense requests that Judge Gold recuse herself for all other just and proper relief in the premises. Richard M. Allen, I swear under the firms and penalty of perjury that the foregoing representations are true. Mr. Allen signs again. Certification comes now. Attorney Brad A. Rossi and Attorney Andrew J. Baldwin, in good faith, certified that the facts and circumstances alleged this verified motion are true and accurate to the best of their knowledge and belief. And we have Brad and Andy's signatures. So that was a pretty crazy, hefty article, or not article, but motion. So at any rate, I will be on tomorrow to share the other rest of the documents. And then I don't know, I'm looking forward to going to these hearings on Tuesday, Wednesday, Thursday. I am still planning to go. It's just, there's so much more. And we can talk about more tomorrow with the other documents. So thanks for watching. Thanks for coming by and listening. I appreciate you. Have a great night. Bye, Crime Chronicles Hub.